Good evening, and thank you for joining us. I'm attorney Lawrence Berliner. I'm an attorney who practices in the field of special education law. Tonight, we're joined by our co-host, Jane Faherty, who's the director of the JumpStart program. We have two special guests tonight, attorney Jim Funnell and Stephen Ehrens, and we'll get into their background and go into tonight's presentation. We are in the second year of these Zoom webinars, and we're still trying to find our voice as parents to meet the challenges of the school year. But tonight we're shifting gears from school to financial planning, trust in the states for people with special needs. So it's not going to be about special education law issues as we've done in the past. We continue to present these Zoom webinars, Jane and I, because we are part of a community of concerned parents and professionals, and we're still learning how to connect in order to get through these difficult times. This pandemic seems to have no end for us. During the past year, we've been moderating a series of webinars to address issues arising in these unprecedented times, mostly educational related, but as I mentioned, we're digressing tonight for special needs trust and related financial planning issues. We have convened tonight to address your questions. We've received many. For those that are going to have not already submitted questions, please use the Q&A format at the bottom of your computer screen and not the chat feature. If you'll notice, the chat feature has all of our contact information, attorney Lawrence Berliner, Jane Faherty, attorney Jim Funnell, and last but not least, Stephen Ehrens. I do have a disclaimer. This webinar is being recorded, and that's one of the reasons we want the Q&A format used, because the chat feature is recorded, the Q&A questions are not. The information provided during this webinar does not constitute specific legal advice to you and your child and your family circumstances, and should not be relied upon as such. The webinar does not establish an attorney-client relationship with myself, attorney Lawrence Berliner, or attorney Jim Funnell, or a professional relationship between Jane Faherty and yourself, or Steve Ehrens and yourself and your family. By signing up, you've agreed to receive information about future webinars from the Law Office of Lawrence Berliner and the Stamford Jewish Community Center, where Jane Faherty works as part of the JumpStart program. Please note that the Zoom is a third-party provider and is not affiliated or associated with the Law Office of Lawrence Berliner, the Stamford Jewish Community Center, attorney Jim Funnell, or Steve Ehrens. We ask that you keep your questions general in nature, and so all of us can benefit from your questions, so it's not peculiar to your circumstances. We do have people from other states, and I don't know, this evening we had last time people from other countries, but I wanted to just point out all of ours are Connecticut focused. So a lot of what we say is based upon Connecticut law, unless we're dealing with national laws like the federal special education law is national, but a lot of this may be peculiar to the state of Connecticut. So we just wanted to point that out. Before I introduce our co-host, Jane, and get into the biography, I mentioned special education. I just wanted to give one announcement that in this past week, this is the 46th anniversary of the signing of it was originally called the Education for All Handicapped Children Act, which is now the Individuals with Disabilities Education Act. It's hard to believe that this law has been on the books for 46 years, and it's still evolving. It's an exciting area for me each and every day. The other thing I wanted to mention, more on a sad note, was the passing of Senator Robert Dole. And it may be surprised that for many people who thought that Senator Dole was a partisan, but when it came to the rights of people with disabilities, he was nonpartisan. And he was one of the champions of the Americans with Disabilities Act. And I wanted to just acknowledge his service to his country during World War II, and being a champion for the rights of people with disabilities, because his service in World War II and being a champion of the Americans with Disabilities Act and other federal laws has allowed us to enjoy the freedoms that we enjoy today as Americans, as people who are benefiting from the Americans with Disabilities Act. So I just wanted to give condolences to the Dole family and just acknowledge how much he has done behind the scenes for the rights of people with disabilities. So our co-host is Jane. Maybe she would like to offer a few words, and then we'll go into tonight's subject matter. I'll give a brief introduction to both Jim and Steve.
Thank you, Lawrence. Hello, everybody. Thank you for joining us tonight at this holiday time of year. And I think because we're on the holidays, it's really actually very pertinent that we're talking about finances today, because everybody kind of, you come to the end of the financial year, you're coming to the end of the year, you've got financial pressures, potentially with celebrations of whichever holiday it is that you celebrate as a family. So having you here tonight, Stephen and Jim, is really tremendous to share your insight and information regarding financial planning, particularly for children and young adults with disabilities. So thank you for joining us tonight. In terms of what I do support programming at the Stamford Jewish Community Centre, particularly a program called JumpStart, which is for children with developmental disabilities, aged between 2 and 3. But I also wear a number of different hats, one of which is as an advocate. So Larry and I will look forward to doing more round tables and discussions in the new year, but it's great to have you here tonight, Jim and Stephen, to talk more about financial planning and how important it is for parents to remember to set aside time to do the financial planning and to work with experts such as yourselves to help alleviate the pressure and the strain when looking forward and looking at the future. So thank you for joining us tonight.
Amongst the many topics we'll try to get through as special needs trust and estate planning, financial planning, ABLE Act accounts, power of attorney, legal guardianships, and how that dovetails with supplemental security income known as SSI, Medicaid, which is also referred to as either Husky here in Connecticut or Title 19. We're very fortunate to have Steve Ehrens, who's an expert in special needs financial planning. He's based in Fairfield, Connecticut. He specializes in financial planning for families with children who have special needs. He's a wealth management advisor, a passionate advocate for not only his own family, but his clients who have children with special needs. Steve can get into his background. He's uniquely positioned to guide parents through the process of developing a customized financial plan and estate plan for their children and their children's future. He is affiliated with Northwestern Mutual in Fairfield, Connecticut. Joining Steve is attorney Jim Funnell, who is a principal of Brody Wilkinson, now located in Southport, Connecticut, which is part of Fairfield, for those who don't know that. His practice is limited to the estate and trust planning, special needs planning for families with children with special needs or young adults, estate and trust administration. He's a fellow of the American College of Trust and Estate Council, a member of the executive committee of the Estates and Probate section of the Connecticut Bar Association. He has a very high peer-reviewed rating in Martindale-Hubbell for over 20 years. He's listed in the best lawyers of Connecticut. I should be there too. He's been named a super lawyer since the inception in 2006. And he's admitted to practice law both here in Connecticut and Texas. So without further ado, we'll go into tonight's topics and questions. And we have some that have been submitted. And as I pointed out, please feel free to add to the questions in the Q&A format. Um, I don't know where to start, but maybe we should start with what are special needs trusts?
Well, I'll start with that. And again, my name is Jim Funnell. I've been practicing for 33 years, and about 27 of that has been largely focused on estate planning for parents who have kids with disabilities. I think there's a few facts that are worth noting. As of this year, 1 in 54 children in the United States is diagnosed with autistic spectrum disorder by the age of 8. That's up 10% from a decade ago. And 1 in 23 children under the age of 18 has a disability. Most of those are intellectual disabilities. We have company. So never think you're alone in this. In my opinion, as an estate planning attorney, nearly every one of those children needs to have a discretionary trust of one sort or another. They run the gambit from high functioning children with disabilities, and in my experience, they're more susceptible to predation than just about any other beneficiary group that I work for. And there is a type of discretionary trust that can be put in place to protect from creditors, predators, and divorcing spouses. So for a parent who wants to make sure that the safety net that they're trying to deploy for their child is indeed only for their child, a discretionary trust that's meant for asset protection probably fits the bill. For children with more profound disabilities, we turn to something called a special needs trust. A special needs trust is intended, at least in most people's minds, to preserve eligibility for need-based benefits. And I really see there's 4 functions. First is we don't want the government to be able to grab any of a child's inherited wealth to repay themselves for benefits that may have been provided to that child. We want the assets in the trust to be protected from creditors and predators. We want to preserve eligibility for benefits, and assuming that that trust lasts for an entire lifetime, which properly drafted and administered it should, the remaining assets of the child's death should come back to family 100 cents on the dollar. The government shouldn't have any recovery rights as to those monies. Pertinent to Steve's part of this presentation, all of that sort of dovetails with a fairly straightforward notion that parents who have children with disabilities are in the incredibly difficult position of planning for enough wealth to address the needs of 2 generations, not just one. They have to plan to address their own needs for a lifetime, but in addition to that, there needs to be enough money to address the child's needs for the child's lifetime. Now, in terms of preserving eligibility for need-based benefits, and there really are fundamentally 2 types of benefits in my mind, or the way I sort them. There's the group of benefits where the only question asked is, does this child have a disability? And there's the group of benefits that ask, does this child have a disability and is he or she rich? Can they pay their own bills? The special needs trust is aimed at making sure that an inheritance doesn't render the child ineligible because they're deemed to be rich. Properly structured, these monies can be segregated so that they benefit the child, but don't affect the child's eligibility for benefits. Most parents would think in terms of, if you've got an estate plan at all, you might say, well, I went to an attorney, I got a will done, and there's a trust for each of my children. And that typically won't get you where you need to go if your objective is to preserve eligibility for benefits for that child. The reason is the typical trust for a typical child is going to say, and I'll use my brother Bill as the example, he's the go-to trustee for everybody in our family. Uncle Bill may distribute income and principal for the health, education, maintenance, and support of the child. Unfortunately, those 4 words in the trust are a death knell for special needs planning. health, education, maintenance, and support include food, clothing, shelter, and medical. And for need-based governmental benefits, the government says, we're payers of last resort. You have a trust that says it will provide for food, clothing, shelter, and medical. Come back and see us when that trust is depleted, and we will consider you broke at that point. And at that point, there's no safety net left. We really need a true discretionary trust, one that says that the Uncle Bill can use the money for anything he believes appropriate in the child's life, and as judged in his sole, absolute, and uncontrolled discretion. So we've got incredibly broad discretion in the hands of an independent trustee. Trustee is the key component to making a special needs trust work. And you really have a very limited group of possible trustees. Family and friends. I throw friends in there, but they really don't show up for this job, at least not very often. Professional advisors, typically attorneys or accountants, banks and trust companies. And in Connecticut, we have the option of turning to the Planned Lifetime Assistance Network of Connecticut. They're actually authorized under the banking laws in Connecticut as a nonprofit organization that can serve as trustee of special needs trust for families who need a trustee and don't have anyone to turn to. I say the trustee is the most important component of the trust operationally, but functionally, the most important part of the trust has got to be the funding of that trust and the ways that we get there. And so one of the easy mechanisms for funding is an inheritance. That child's distributive share of mom and dad's estate, whatever that may mean. And there's retirement plan assets, and there's gifts from other family members. Don't underestimate what grandma and grandpa can do. I've seen wonderful things done, especially with in payment for life insurance policies and things like that. And life insurance. I mean, you know, I've got issues in my life that are bigger than my pockets are deep. I can't absorb all that risk. I need to lay that risk off on somebody else. To me, that's what life insurance is about, in this context especially. And with that, I am not a financial specialist. Stephen is. I want to turn over to him at this point.
Can I just stop you there a second, Jim? One of the concerns with the families that I work with is the trustee element. So I have friends who they are themselves only children. They have no siblings. They have children that have needs. They don't have other typical children that could potentially be there to support and oversee. So while they have friends at their age, their peers, that's not going to be much help when they're looking for people that are the younger generation that are going to be there to help steward and take care of the trust for their children, you know, once they're no longer here. And so can you just explain just quickly and reassure families that organizations such as yourself can work with other organizations that can have trustees embedded within that, so that if one trustee were to pass, there's a succession plan in place for that trustee?
Sure. A properly drafted special needs trust should address a succession of trustees. What I tell most families is the first thing you want to do is ask yourself, if I check out in a blaze of glory on I-95 next weekend, what's the best answer I've got for the next 5 years? And that's the person who you should name as trustee. You're not trying to put in place the trustee who's going to be there on the day your child dies. We need the person who's the best person to serve those needs immediately. And then we need to build mechanisms in the trust to arrange for a next in line, a successor. I've named my brother Bill. If he fails or ceases to act, I've got my brother Richard. If Richard fails or ceases to act, I have the right to remove and replace a trustee anytime during my life. When I'm gone, my daughter Charlotte has the right to remove and replace a trustee. So we've got a lot of long range options for making sure that someone is in place. But fundamentally, we're still drawing typically from the family group. And by that, I don't mean siblings. Siblings cannot generally serve, at least as I draft, they cannot generally serve as an independent trustee of a trust, because the sibling is likely to be the person who receives whatever may be left at the death of the child with a disability. And if all you have to do to get more is distribute less during lifetime so that you can get more upon the death of that sibling, there's an inherent conflict of interest. So beneficiaries typically can't be that independent trustee. So we're looking for people who have no dog in the hunt as independent trustee. That could include a professional, an attorney or an accountant. But on that, I'd caution that if the attorney you're meeting with for the first time says, and don't worry, I can serve as the trustee, I'd be afraid of that. When I say consider an attorney or an accountant, I mean somebody that you've known for long enough that you can make a judgment about who they are and whether they bring the skill set you need. Bank and trust company, it's a possibility for some families. It's not for me, and it's not a possibility for a great many of those I work with, simply because the cost of entry is pretty high. I don't begrudge anybody making a living, but you need a lot of money to attract the attention of a bank or trust company in a special needs context. And that leaves for those who have no choices. And I don't mean to pick on anybody, and I'll apologize in advance for overgeneralization, but some disabilities tend to be family cohesive, or at least more cohesive than other disabilities. I do work with the National Alliance for the Mentally Ill, and every parent in private will acknowledge that quite often other family members don't want to get involved. Situations are too volatile, too unpredictable. Nobody wants to get involved. And in those cases, we have organizations such as Plan of Connecticut who have trust powers and can step in and be the trustee when there is no other option. I hope that's.
Yeah, thank you so much. That was extremely informative.
I just want to point out that Plan of Connecticut's contact information is in the chat room. And Jim, correct me if I'm wrong, according to the state of Connecticut, you mentioned rich. Rich means having liquid assets over $2,000. Is that correct?
It's $2,000 in most states. It's $2,000 for SSI in Connecticut. It's $1,600. That's the dividing line between rich and poor. $1,600 for all other benefits. So,
right. So we're not talking about thousands and millions of dollars. We're talking about 1,600 or 2,000.
The safety net that they're allowing to a child is not extensive.
Well, you mentioned how to fund, and that's where we have Steve Ehrens. So I sort of have a three-part question, on financial planning, the best way to fund a special needs trust. And maybe Steve can explain the ABLE Act account and how the ABLE Act account works.
Thank you, Larry. Thank you also, Jane and Jim, for joining me here tonight. I appreciate you having us here, and I hope I can be of some beneficial information to everyone who's attending this webinar. So I think maybe a good place to start is kind of at the beginning, because people often say, well, I'm not sure my child is special needs enough to do special needs planning, or when should I begin to do special needs planning? And when my daughter Liz was born, she was 1 pound 9 ounces, and she was in the neonatal unit, the NICU at Yale New Haven for 3 months before we brought her home, and we knew there was going to be a problem. So what did we do? How did we begin? What were our thoughts in terms of planning for the future? And I think some of the things that we did is we recognized initially that there might potentially be a problem. So just by recognizing that there might be a problem led us to think that we needed to think about not only our future, but her future, and what might we do to protect her future financially. And I think Einstein was the one who came up with the 8th wonder of the world, which he called compounding. And compounding, of course, works incredibly well. the sooner you start. So we realized right off the bat that anything we did financially was going to have a much greater impact on her life if we started doing it sooner rather than later. We also quickly learned that assets in her name potentially could be disqualifiers for her in the future, especially starting at age 18 when she goes out to look for SSI and Medicaid, which we've just touched on. So we recognized that we didn't want to put assets in her name, no 529 accounts, no bank accounts, no savings accounts, no savings bonds. We wanted to essentially impoverish her. We wanted to do something that would protect her and maybe build assets for her in the future, but we also wanted to do something that would be very flexible. And flexibility to us was sort of the key to planning for the future, because when she was just born and we had no sense of her future, the question we had at the time was, what is she going to need? How much support is she going to need? What is it all going to cost us? And how do we provide for that? So we basically started looking towards the future and started to prepare the way. Now, in 2016, we got very lucky in that President Obama put forth some legislation to provide a new type of account called an ABLE account. And up until 2016, again, there could be no assets in our children's name. Otherwise, they would not be eligible for benefits. An SSI, for example, is worth $794 a month. So that's obviously, while it's a minimal benefit, it is still a benefit, and it's a benefit that most families want to reach for. So they developed the ability for us to use ABLE accounts as an additional means to put money away for our children without jeopardizing them from receiving SSI, Medicaid, whatever other benefits that they might be eligible for. So essentially, the states hooked up with the same people who are doing 529 plans in those states and allowed them to put forth these ABLE accounts. So the ABLE accounts essentially are accounts that can be put in place where monies can be placed that will not disqualify our kids from getting the benefits they're entitled to. Now, there are limitations in terms of these accounts. The maximum amount that anyone can put into an account would be $15,000, and we can only have one account per beneficiary. So for my daughter, Liz, we can have one account. We can go to any state where the account is offered. And currently there are over 40 states, including Connecticut, that offer ABLE accounts. But I can contribute, grandma can contribute, my brother, my sister can contribute to this account, but no more than one account and no more than $15,000 per year can go into the account. Now, that being said, Liz can actually contribute into the account any money that she earns up to a limit of $12,760 a year. So it's possible for me to put in $15,000 and for Liz to put in $12,760. So we could potentially have $27,000 that goes into an account in a particular year. The money that goes into the account will grow tax-free when you select the state that you want to participate in, and you can go into any state's program. There are a group of investment options. So I happen to select for us the Ohio ABLE account. Now, I did that because, not necessarily because it was the best one, but because it was one of the first ones. And I wanted to get into this program as quickly as possible. And I've been in this program since the beginning, and I've found that it's very easy to maneuver through. The access online is very simple. The investment options, and they have 4, are very good. The fees and expenses are very low, and there's also a debit card attached to the account. Now, the money in this account will grow totally tax-free and can be used for any and all expenses related to Liz's disability. And the way I manage this account is Liz has a debit card, and I essentially put $400 at a time on that debit card, and she takes that card and she uses it when she goes to ShopRite. She uses it at Target. She uses it when she goes out to dinner. She uses it pretty much anywhere. When she goes on the train, she uses it. She pretty much uses it anywhere she needs to spend money. She doesn't really carry money. She just carries this debit card. And the nice thing is that I can go online and I can see at any given time exactly where this money has been spent. The risk of predators and people, maybe taking advantage of her is only limited to the amount of money that I put on the card. So while I have significantly more money in the account, there's only $400 at a time on the card. In fact, recently she was changing trains in New Haven. At the train station there, she was going from Metro North onto the local line, and she somehow, in the tumult of it all, she lost her Able account debit card. So I went online the next day. I saw there was no unauthorized activity. I stopped the card, reordered a new one. Within 5 days, she had a new card in her hands. Now, all that being said, this operates almost as if it were a checking account for her. It gives her money. It gives her the ability to spend money. But as I said previously, it will not disqualify her from receiving whatever benefits she's receiving. Now, all that being said, these accounts are limited to a maximum amount of $100,000. So if the account were to grow beyond $100,000, her SSI would be suspended. So the government is not setting these accounts up for hundreds of thousands or millions of dollars to accumulate in. They're setting these accounts up so that they can put some money in them, so they have some of their own money, so they have some responsibility for spending their own money. So this money in this account can improve the overall quality of their lives through their direction and their discretion. So we can't allow this account to grow to more than $100,000, otherwise benefits will be suspended. Now, the other negative to this account, and Jim talked about this with the Special Needs Trust, is that when Liz dies, and she will at some point, whatever money is left in this account will be used to pay back any governmental agencies that provided any services for her. So if she were to die and there were $50,000 left in that account, that $50,000 would go to the government to pay back for benefits paid. So that is a negative. Now, that being said, again, this account is primarily used as a current spending checking account for her. Jim just spoke in detail about a special needs trust. The special needs trust, on the other hand, is designed to provide a lifetime of support for Liz when I am no longer here, when my wife is no longer here, when we need to have substantial assets to essentially fund her entire life. Liz is now 29 years old. She lives independently, and her expenses are substantial. And we are going to have to fund her life for the rest of her life, and we're going to need substantial monies to do that beyond what is in her ABLE account. So what we've done is we've purchased life insurance to fund the trust. Why life insurance? Well, because it's inexpensive. If I were to decide to fund the trust with $1 million of my assets, I could save $1 million, or I could purchase $1 million worth of life insurance. If I were to do that, purchase $1 million worth of life insurance, that then would pay at exactly the moment I needed it, which is when I die. As long as I'm here, as long as my wife is here, our daughter Liz is going to be just fine. But when we're both gone, that's when we need to make sure that there is money in these trusts to essentially provide for her. You know, I was talking to someone the other day who got a tremendous amount of benefits. I was shocked at what this individual was able to find and secure for her daughter, and almost enough that she felt that her daughter is going to be totally self-sufficient. But her concern is that what if the government runs out of money? Is that possible? Could our government actually run out of money? I think that's clearly a possibility. So this individual's concern was they don't want to take any chances. They don't want to rely only on these benefits that are there and available today. They want to make sure that there's going to be money there when mom and dad are no longer there. So they then have purchased life insurance. Now, that life insurance, which has been purchased to fund this trust, is typically a policy that is on mom and dad together. This is what's called a joint policy. And the reason we typically use a joint policy is because it's less expensive. So now mom and dad have passed away. We've funded this special needs trust with life insurance. We purchased it when Liz was very young, so we had the power of compounding working in our favor. By the way, we were young, we were healthy, so it was very easy to get this. Now we die, the special needs trust is funded with the life insurance, and we happen to have a very smart trustee. And that trustee sees that there's money in Liz's ABLE account, and he sees that there's money in the special needs trust. Well, the first thing he's going to do is he's going to spend the money in the ABLE account because the ABLE account has the payback provision. That fund in the ABLE account is then depleted, and then the money that's left is the money that's sitting in the special needs trust, which will be used for Liz's benefit. And should there be any money left at the end of her life, whatever money is left, that will then be distributed to her children if she had any, or to her sister and her sister's children. By the way, Jim made a comment, which I thought was a very good one, about conflict with the trustees regarding the monies in the trust, and what if the trustees are family members. What we did is we did have family members, but we wrote them a letter. First of all, we trust the trustees, and we wrote them a letter saying the money in the trust is to be spent on giving Liz the best quality of life possible. The money is not to be saved and held on for future generations. This money is for Liz and for Liz's benefit. Should there be money left, then of course that money would be distributed to other family members. But that's not the purpose of the trust. It's to give Liz the life that we want her to have.
Well, Steve, we have a couple of questions I'd like to present to you. You mentioned the $15,000 per year cap on contribution. One of our questions was a person is getting a pension distribution at age 65. Is it possible to roll over that pension distribution into the ABLE Act account if that amount is less than 100,000? Would your $15,000 per year cap, dovetail with that even if they have the pension distribution, but the cap, because of the $15,000 cap, the only thing they can put in is up to 15,000?
Yes, it's 15 is the max. Now, you could put 15 in on December 31st and 15 in on January 1st, and you would then have put in $30,000 within 2 days of each other.
Okay.
But 15 is the max. Now, another interesting thing that you can roll into a ABLE account, a lot of parents made the mistake, or they were actually doing the right thing, so they thought, and they set up a 529 account for their child when their child was born, or maybe very early on, or maybe the grandparents set up the 529 account. Now, the 529 account is limited in that it can only be spent for education, a private school, college, grad school, etc. If parents set up a 529 plan, they can actually roll the 529 plan, unfortunately limited to that $15,000 a year, but they can roll the 529 plan into the ABLE account. If they were to do that, they could still use that money for college or grad school or high school, or the same programs that the 529 plan is designed for, but they can also use the money, if it's in the ABLE account, for anything else related to their disability. So it's much more flexible. It has the same tax advantages as the 529 account, but unfortunately, and I've run into many families that have very significant 529 plans. Unfortunately, we can only roll the 15,000 a year.
So if you just a quick quote, if you wanted to give more than 15,000, but you're not allowed to do that with the ABLE account, could you roll that money into a trust?
Sure, you could roll that into you, and Jim can touch on this, but there are essentially two types of special needs trust. One is called a testamentary trust, which is embedded in your will, or one is called an inter vivos trust, which actually exists. You get a tax ID. It could be at a bank, an insurance company, an investment house, and you could fund that trust currently. So if you had monies beyond the 15,000 and you wanted to fund a trust currently, you would set up an inter vivos special needs trust. And this is particularly important if you have grandparents. You know, grandparents tend to love their grandchildren more than they love their children. And in many cases, they want to leave Liz money. They don't necessarily trust me, but they want to leave money for her. So that might be a reason to set up an inter vivos trust with a bank or an insurance company today, where you could actually fund that currently with other dollars. Jim, do you want to comment on that?
I use the irrevocable lifetime trust, what you're calling the inter vivos trust, almost exclusively. And that's driven by the reasons that you've already pointed out, but also an experience that I seem to have over and over again. And that is the biggest threat to a child's inheritance, including that life insurance policy they bought a long time ago to help fund the trust, is that one or both of the parents ends up in a nursing home and start spending money hand over fist. And among the first things to go is the low-hanging fruit, including the cash balance in a life insurance policy. I would rather have an irrevocable trust up and running. I would like it to own the policy eventually anyway, and put those monies that policy represents beyond the reach of the parents' creditors.
One question we had, how much money do we put into a special needs trust? I mean, how do we project out into the future expenses? Is there some formula? Is there some website that a family can go to and say, on average, you should have $5,000 a year available and compounding and putting all these assets so we can project out how much the contribution should be over time?
So that's an excellent question, Larry. And of course, as time goes on, we tend to get a better sense of what our child's future is going to look like. And by the way, that future can vary greatly from a severely disabled child where he or she may be in a group home where most of their needs are being provided for through Medicaid and SSI, to someone like my daughter, who's a little bit higher functioning, not receiving nearly the level of benefits, is living independently, but is participating in the program that has significant costs associated with it. So we kind of have to sit down and envision what that future might look like. Would that child be able to work? If so, what could they potentially earn? Will they need group housing? Will they live at home? Will they live with another family member? And we actually have a budget that we sit down and we calculate through what that future might look like and what those costs might be. Now, the other side of the equation, which is probably as important, is what is going to be left to fund the trust with in terms of mom and dad's assets. So most families that I work with, the families own a house. They, the father or the wife, whoever the working spouse is, has got a retirement plan, maybe a 401k, maybe they've saved some money. They're planning on retiring at some point in time. They may want to sell their house and downsize. They're going to draw money out of the retirement plan. How much money is going to be left? That is one of the things that we have to calculate. And in many cases, there may not be anything left. Or there may be some left. How will what's left be distributed? Even though we have a child with special needs, we have 3 children. We love them all equally. they may be the ones who act as trustees on the special needs trust. If we leave all the money to our daughter with special needs, and then the other two children, our typical children, are the trustees and got nothing from mom and dad, what kind of dynamic does that set up in terms of them feeling like they were robbed, they didn't get their fair share, and they're not going to treat their special needs sibling the way mom and dad necessarily wanted them to. So what we typically recommend is, after we've calculated out what we think will be left, we typically recommend mom and dad split those assets equally amongst all their children, and then supplement the needs of the special needs child with a life insurance policy. We also advise a nice big family meeting where everybody lays their cards on the table before mom and dad check out, so that if anyone has any problem with any of this, that they let their concerns be known before it's too late, so that the family doesn't end up with a major battle and everybody feels like they've been treated fairly. So we have the software that does the calculation, but it's only through a lot of discussion, a lot of calculating, a lot of thinking and visiting and revisiting over the years to sort of figure out what that number might look like. Now, just one other little piece of this, generally speaking, we figure $1 million in a trust will generate about $40,000 a year of income. So that's kind of the parameters that we're using in terms of what a life insurance policy should be, what it might look like, and what's it going to be able to generate in terms of income for that child with special needs.
Steve, you've been talking primarily about life insurance, cash, financial assets. Can a special needs trust own tangible property, real estate, anything like that, stocks, bonds?
Yes, so a special needs trust can own really any asset at all, but you want to think a little bit about these assets and how they might work inside the trust. I recently worked with a family and they said, we're not going to buy life insurance. What we're going to do is we're going to use our ski house in Stratton Mountain, Vermont, to fund the special needs trust. That's going to be the primary asset. So I thought to myself, well, what happens if it's a year when there's no snow and they can't sell the house? What happens if the real estate market has tanked? What happens if we're in a recession? So, while it's a great idea to use a ski house to fund the trust, in terms of what it's ultimately going to be worth, that's a big question mark. And of course, the nice thing about life insurance is it's worth 100 cents on the dollar. We don't have to worry about recessions. We don't have to worry about, snow conditions. All we have to do is put in a claim and we're going to get 100 cents on the dollar. And I just want to make one other comment regarding the trust itself. Once it's funded, and this is a place that people typically make a mistake, once the trust is funded, they have to realize that a tax return will be filed every year. The trust is a living, breathing, taxable entity, and will have to file tax returns. And the tax rates that trusts typically pay are very, very high. Some people think that a trust is a tax-free vehicle. Remember, the ABLE account is a tax-free vehicle. The money grows tax-free and it could be spent tax-free. But a special needs trust, once funded, will be taxed at the highest rate in the land. And that, of course, is going to deplete upon the earnings significantly.
Well, Jim, we had a question. What happens if the beneficiary of the trust dies? We've been talking about what happens to when the parents pass away and are leaving assets to the child, but what would happen if the child himself or herself passes away? Is there something that a trust document would cover that contingency?
You're muted, Jim.
The trust is drafted to anticipate the reality that child with a disability is going to die someday. and remainder beneficiaries are named in the document. The trustee who's in place at the time of the child's death is in charge of making sure those assets get to the remainder beneficiaries and the shares that have been laid out in the document.
And Jim, can you tell us the difference between power of attorney and guardianship?
Yes, I think we start with a very basic concept, and that is every person, with or without a disability, is accorded or afforded self-determination. They can make all their own decisions unless a court says otherwise. Once they're 18 years old, they're an emancipated adult and they make their own decisions. A lot of parents want to respect that right to self-determination to the greatest extent possible, and will want to be able to help make decisions and participate in decisions. For that parent, we would look to a power of attorney, where the child would sign the document naming the parent as an agent to make those decisions if the child were unable, or to help the child make those decisions, but also participate in educational decision-making, be a participant in that process, and the power to hire advocates on behalf of the child. All of those are sort of important facets. There are circumstances where the child isn't able to appoint an agent. And under those circumstances, we would turn to the probate court and we would ask the court to make a determination that indeed the child isn't in a position to make those decisions himself or herself. And we'd ask the court to appoint a court supervised agent. In Connecticut, that's called a guardian under the Intellectual Disabilities Act, where we have an IQ of 69 or less. Where the IQ is higher, the Intellectual Disabilities Act doesn't give us the same quick and easy answer, and we have to turn to something called conservatorship, which is an application filed with the court where the parents typically have to provide medical evidence of the nature and extent of the disability. And it's up to the judge to make a determination whether that child's right to make decisions should be removed from the child and placed with the parents instead.
And can you just explain the difference between that and a healthcare proxy?
Sure. The financial decision-making is, and I guess financial decision-making, personal decisions along the lines of education and things of that sort are left to the agent under a power of attorney. A healthcare proxy is, I guess we start with the Cruzan decision of the US Supreme Court that says everyone makes their own healthcare decisions. But if the healthcare proxy says, if I'm unable to make those decisions as determined by the doctors who are treating me, then the person that I've named, my parents, for instance, are given the authority to make those healthcare decisions on my behalf. And we typically want a HIPAA authorization in place as well, so that healthcare providers can share medical information with the agents who are charged with making decisions. You know, if we're going to let them make decisions, we might as well let them make informed decisions.
We have a couple of questions that are the same opposite side of the same coin. You know, when do you start planning, and is it ever too late to start planning and setting up a special needs trust?
So long as you're alive, it's not too late to start planning. I think Steve's absolutely right. The sooner you get on the job of doing the planning, the important component of having the dollars to deploy as a safety net. That's functionally what a special needs trust tells the trustee is, let the government pay for everything it's willing to pay for, use the dollars in the trust to fill the gaps we know are going to be left behind. Well, we need to have those dollars to fill those gaps. And the earlier that they start, the more likely it is that we're actually going to have those dollars. So start early. save often, but even for a parent who I get a call from a hospital, I need to be sure this child's inheritance will not interfere with eligibility for benefits. We can do it right there on the spot, even knowing that whatever happens to be left after the hospital bills are paid, that's what's going to be deployed for the children, and that child's going to get their share in the form of a special needs trust.
If a parents are divorced and one parent has sole custody, does that parent then have the sole discretion regarding the financial planning and trust for that child, or would it be possible for both parents, if they don't have common ground, to establish two separate trusts for the child?
They can have separate trusts. It certainly is better, I think, it's more functional if they can come to an agreement that they do have a child who has these needs and both can come up with a common mechanism for funding, because the needs aren't going to go away simply because the parents disagree on how they should be satisfied. So if they can agree on a single trust, that's a better strategy. I'd also point out that in the context of a divorce, the family law judge who decides the case has authority to direct the creation of a special needs trust, and also how that trust may be funded. If you need something with a little bit more teeth, that may provide it.
We just had a question. Typically, how much would it cost to establish a trust? How much are the legal fees or the startup fees for trusts and accounts?
Well, as part of a greater estate plan, there's two pieces. There's the trust itself, the special needs trust, and then there is the family estate plan. To put together a special needs trust, the least expensive way of doing that in Connecticut, I believe, is through Plan of Connecticut, if they happen to serve your needs from the standpoint of trusteeship. And that would cost, I believe it is $1,050 paid to Plan of Connecticut to establish the trust. And then you'll have to buy a couple of hours worth of time from someone like me to help put that trust in place. So that might be $2,000, $2,500, give or take. To privately draft that trust, however, if I wanted Brother Bill to be in charge and I wanted all the bells and whistles of right to remove and replace and have another child be able to step in, or have other family members participate, it's probably twice that cost in order to create the special needs trust. Then you also need, at the very least, wills. The wills for a married couple may just say, I love you, honey, here's everything. And if I'm the second to die, divide everything equally among the children, but Jimmy's share goes to the special needs trust created for his benefit back in 2021. It's hard to put a number on that because there's so many permutations we can get into, but the least expensive you're going to get away with something like that is probably in the similar $2,000, $2,500 range. But that could also go much higher, into the 5,000 plus range, just for that piece of the puzzle. If you said, well, I want Charlotte's money to be protected from creditors, predators, and divorce for the rest of her life, even though she doesn't have a disability. I just don't trust the rest of the world. Those kind of plans get more expensive.
Sure.
Jane, I just want to make two comments on the past couple of questions. First of all, you asked, you were talking about divorce and the two different parents and who's responsible and what can and can't be done. And I just wanted to let you know, I previously mentioned this idea of life insurance on mom and dad together as a way to fund a special needs trust. And why we do it on mom and dad together is because we need the money when both mom and dad are gone. And we also do it because it's going to be less expensive than doing it on just mom or dad. By doing it on both of them, the cost in some cases can be half of what the cost would be on either one of them individually. However, if parents are divorced, they have a common interest, which is this child with special needs. And many companies will still offer this type of insurance policy. And even though they are divorced, they can still do this policy where they both are, in fact, the insureds on the policy. So that's one point I just wanted to make. The other point was, when do we begin? And of course, we begin as soon as we possibly can. And what this is really about is amassing as much wealth as we can, whether we amass it through our 401k, whether we amass it through saving it in an investment account, or whether we amass it through the purchase of life insurance. The key is to start sooner rather than later, but to build flexibility into the program so that no matter what happens with your child, you're going to have this safety net is there. So if Liz does better than I ever thought or dreamed she would, well, all I've done is I've created more wealth for my other children. I've accumulated more money for myself. I'm helping myself in terms of building a retirement plan for my benefit. If on the other hand, she doesn't do as well as I hope and dream, well, I've put the safety net in place that's going to provide for her no matter what when I'm gone. So flexibility is key. Jim used the word irrevocable a couple of times. And when we do things that are irrevocable, that means we can't undo them sometimes, and we can't redo them, and we can't change them. What we try to do in the world of financial planning are things that are not irrevocable, so that no matter what direction our children go, we've done things that if they're not going to benefit them because they may not need it, we're doing things that will in fact benefit ourselves or others.
We had a question of a parent with a child with autism, and the question is a legal guardianship permitted if they have autism but not an intellectual disability? And Jim, correct me if I'm wrong, in Connecticut, we have legal guardians of individuals with intellectual disabilities, but we have conservators of the person for any other kind of disability. Is my understanding correct?
Exactly right. Yes.
So the answer to the question, if you have a child or a young adult, and I might add the legal guardianships, you can't apply before age 18. That's when you contact the probate court several months prior to age 18 for either a conservatorship or a legal guardianship, because parents are the decision maker for minor children, but when they turn 18, your minor child is now legally an adult. We have a couple of questions. This one is right up Steve's area. Is there a benefit of term insurance versus life insurance for a special needs trust?
So term insurance is just that. It goes for a term of time. So that term is typically 10 years, 20 years, 30 years, but actually most term insurance expires before people die. Actually, I think statistically 98.5% of term insurance expires before people die. Term insurance is a great way to protect your income while you're relatively young until you retire during your working years. Term insurance will not fund a special needs trust unless you happen to die prematurely. The good news is that most of us will not die prematurely. Most of us will live into our 80s, maybe even our 90s, and we're seeing more and more people living in their 90s and beyond. So term insurance isn't going to do the trick. What we need is what's called permanent insurance. And permanent insurance is just that. It's permanent. It doesn't matter if you're 60, 70, 80, 90, 100, or 110. When you die, the policy is going to pay. It will last your entire life. And because of that, it's also going to cost more. The term insurance, if we know that 98.5% of it is going to expire worthless, but with the permanent insurance, we know that 100% of it is going to pay, the insurance company is obviously going to have to collect more money if they know they're going to have to pay the claim. In the world of permanent insurance, there are many different flavors. There's something called whole life, universal life, variable life, guaranteed universal life, equity indexed universal life, and on and on and on. So it's very important that when you look at these options, you work with someone that truly understands all the options that are available in the marketplace, and someone that you trust. When I work with clients, I typically shop the market to look at all the options from all the companies to try to provide the best fit for their situation and the best product to ultimately be there to fund the trust.
Are there variations amongst the 50 states? So if somebody's living in Connecticut, the rules may be different than in, say, if they lived in New Jersey or New York. So are there peculiarities that somebody who lives in another state should check with their local jurisdiction, attorneys who practice in that state?
Yes, certainly. Every state has its own idiosyncratic implementation of Medicaid, for instance. And while the rules are pretty much the same state to state, there are nuances that make big differences. States are allowed to apply to the federal government for something that is called a waiver, where they say, look, we've got a special situation here. We want to try something that's a little outside the box, and they'll get permission from the federal government to do that. Well, they've got to establish the rules to make that waiver program work. We have the Katie Beckett waiver. That's one of the more famous waivers in Connecticut, because it was one of the early functional waivers that was put in place. But indeed, most benefits to individuals with disabilities over the age of 18 are funded through waiver programs, and at least in Connecticut. So all the rules vary from state to state. You really need to check a professional in the state where you're living to get the best answers.
Excellent advice. And just I had pointed out at the beginning that all of us on the panel practice and live here in Connecticut. So if you're coming from another state or another country, make sure you follow Jim's advice. Check with your local jurisdiction, attorneys who practice, financial planners who practice in your state. It looks to us that most of our questions for this evening have been covered. So I want to thank Steve and Jim for participating, and Jane for being a co-host. We will continue these conversations into the new year. This is the last one we have. We expect to have a next one on January 11th, 2022, which will be a roundtable discussion on special education law and reviewing issues and concerns that need to be discussed. We're still putting that webinar together. If you're enjoying these conversations and webinars, please do not hesitate to register for these into the future in the chat area. There's a lot of labor that goes behind the scenes for these webinars. So I also want to thank my daughter, Rachel, who's done all the behind the scenes work in setting up the webinar, getting the announcements out, contacting Jim, Steve, and others just to make sure this webinar runs as smoothly as possible. So I want to wish everybody a happy and healthy holiday season, whatever holiday you may be celebrating. We have multiple celebrations this time of year. And I will turn this over to Jane for her concluding remarks, and Steve and Jim as well.
I just want to thank, first of all, Steve and Jim for coming on tonight. It's been an extremely informative webinar. We've had lots of wonderful questions that you were able to answer for our family. So thank you so much for that. And if anybody has any additional questions, I'm sure you can reach out to Stephen and Jim privately. They did leave their contact information there in the chat. Thank you, Lawrence, for the wonderful year of webinars that we've been able to pull together. And thank you to Rachel and also your wife as well for the great support that they've both provided. With regard to JumpStart, please check out our Facebook page for future upcoming events, both socially, recreationally, and educationally. And I hope you all have a healthy, happy end to this year. and enjoy the holiday season. And I look forward to joining you all again in January.
Thank you all for allowing me to participate this evening. I appreciate it.
So one last comment that I would make is that a failure to plan is a plan to fail. So I would encourage everyone to get to work and do something. And what you'll find is that that something will give you an incredible amount of peace of mind. And my daughter Liz all the time says to me, Dad, what's going to happen when you're no longer here? And I look at her and I say, Liz, you're never going to have to worry. Everything's been taken care of. You're going to be just fine. And one other thing, I just want to put in a shameless plug for myself. So I am actually licensed in every state in the US. So I practice, unlike the attorneys who are limited to practicing only in certain states or states that they are licensed in, I practice essentially everywhere. And I'm happy to speak and talk with anyone, put together at no cost a financial plan to help them provide a clear view of what the future might look like and a plan that might make sense based on their situation.
Thank you.
Very good words. Thank you all. A happy and healthy and safe holiday season. And we will see you in the coming year.
Thank you.
Take care.
Thank you.